you will know, as we are in different type of businesses, either you are trade with China or you are working with Chinese investors. You can be in a technology transfer businesses, and you can be in cultural and exchange, education or collaboration with China. But in all this collaboration with China, IP is one of the top issues for many Western business with doing business with China. And since I started advising Western organizations to do business with China, IP has always the issue. However, nowadays the improvement is already there. So today you will be listening about these details later with the speakers. In the meantime, what we would like to tell you is that within the collaboration, to be successful, when it's cross-cultural, there are many elements involved. And for Crayfish, it's important for us to share that knowledge and best practices with everyone who's interested in doing business with China. And we will be focusing on various parts of those elements in the coming series of our webinars. So watch this space. So during those years of working with Western clients, I have many companies doing very successfully in China, including IP licensing business in China. However, I've also seen other businesses losing their intellectual property, got their IP ripped off, products counterfeited. What made the difference is the preparation and to develop and implement a good IP strategy and protection. That's why we have invited today two very experienced China IP specialists from our partner IP law firm Kangxin from China to speak on these important issues. The first speaker will be Nell Greenhouse. Nell is a bilingual legal consultant and case manager specializing in IP law, having lived in both advising Fortune 500 and SMEs, and have a deep understanding of the cultural business landscape and challenges focusing business, foreign business operating in China. So Neil will going to talk through us all the current trends of IP, and she will be also there available to answer questions later. So Neil, over to you.
Hi, thank you very much for that wonderful introduction. It's a pleasure to be here today to speak to you all about IP in China. My name is Nell Greenhouse, and I have been in China for 5 years now. And generally speaking, when I talk to people about my job, the first question that people ask me is, IP in China, does it exist? Clearly, this is a fairly reductionist statement, but it kind of speaks to the broader concerns that I think a lot of Western businesses have when operating in the Chinese market or when working with Chinese companies. And I think one of the really positive things at the moment is that there are some clear trends as to a clear strengthening of IP law in China, which was set about in 2008. The government put forward an IP strategy to strengthen IP by 2020. And they've really made a lot of progress in that. I think the first and the most important point is the innovation that is being driven within China. And this transition, I say transition, towards an innovation economy. Actually, in 2018, China broke into the top 20 most innovative countries in the world, okay? So they were number 17, which is behind France, but ahead of Canada, Norway, and Australia. And I think this is really telling of the push towards strengthening of IP and strengthening of rule of law in this environment, okay? There's a real increase in government incentives for companies working in China and doing R&D in China. There are really quite strong tax incentives. There's something known as the super deduction for corporate income tax on R&D costs, and many grants and subsidies for people applying for patents. And when it comes to trademark law, actually in 2017, official fees were halved. They were halved by the government in order to incentivize companies and individuals to apply for more trademarks. And this is clearly working. In 2017, both patent filings and trademarks filings were more than 40% of the entire worldwide total coming out of China. And it's fun. There's a figure of in 2017, trademark filings are actually up by 55%, if you can imagine quite to the extent at which IP has taken off here over the past sort of 10, 20 years. It's really quite striking. So along with that, we have strengthening of IP laws. Okay, so in 2017, they revised the anti-unfair competition law. And this, it sort of broadened the definition of bad faith as to an act that causes confusion, any act that causes confusion and could be misleading to a consumer, which it's really positive in terms of catching more forms of infringement. Another thing which we are anecdotally seeing when we're working in the field when we're litigating is that there seems to be much higher levels of compensation being awarded over the past few years, particularly over the past year, and that's a really heartening trend. So other than just compensation, what other enforcement measures are we seeing? Okay, so one of the interesting things, which I'll talk a little bit more about later, are the specialized IP courts, which are very common in China in major cities and now in some regional cities. So there's one in Guangzhou, Shanghai, and Beijing, and some smaller second-tier cities are also getting them. And what this means is that a large number of cases are actually being handled by specialists, people that really understand the field. And it's making this large number of filings and the large amount of litigation that necessarily needs to be processed much more efficient, much quicker. Not only that, but when it comes to administrative measures, they're also more efficient. We have the AIC for trademarks, who, the moment that you file an application with them, they will go into a factory and they will seize the goods and perform infringement analysis and destroy them if necessary. At the same time, it's not just these bodies, but also we have private companies like Taobao and Alibaba. And I know that these are platforms that a lot of companies are concerned about having infringing goods sold on. But what is heartening is that a lot of these companies have their very own infringement departments who specifically deal with IP issues on their platforms. So that means that if you find fake goods, infringing goods, or something bearing your trademark or your logo, something that invades your copyright being sold on these platforms, if you have good Chinese, you can apply to them, or if you know a good Chinese attorney, you can apply to them to have these taken down. Okay, so in the context of the trade war, we're also looking to, I think, some really interesting and quite exciting developments in Chinese IP. And one of the things which has come out of this was in 2018, at the end of 2018 in December, is proposed revisions to the patent law. And there's a first draft put out then, which addresses the concerns of forced tech transfer, which, there is some debate whether statutory measures are actually going to be effective there. But more importantly, when it comes to patent law, the current level of fines that are imposed for patent infringement are set at 1 million. This new law will increase that to 5 million, which is just under $1 million USD. And that's a really heartening, progress. Okay, Zhao, could you help me move to the next slide, please? Okay, so aside from these trends, what makes Chinese IP different from other systems? First of all, I think one really big difference between particularly UK IP and Chinese IP is that the moment at which your rights are protected is not the moment of application, not the date of application, but rather the date of registration. Now, what does that mean? Okay, so if you have a patent and you apply, okay, you will be protected, that priority date will be protected from the date that you apply, but you will not be able to enforce that, or it will be difficult to enforce that until after registration. The same goes for trademarks. Where you have applied for a trademark, the prior rights date will be reserved, so the date which you apply for that trademark. However, that is not something that you will easily be able to enforce until registration. Of course, we can look at other methods, for example, copyright law, to help if there are graphic design elements. But it is more difficult to face infringers until after formal registration. Okay, and our specialized regional IP courts, I've already spoken a little bit about these, but they are really a really great system. They're very efficient. You have some really smart technical people who have a deep understanding of the matter at hand and will look into it and actually understand the technology if it's patent law. So I think that's, it's a speciality of Chinese IP, but I think it's a really good way forward to deal with IP efficiently instead of going through traditional courts who aren't necessarily so well versed in IP law. Okay, the next section is, I think, something that everybody hates to hear, but it's the comparatively low level of compensation that is awarded in these cases. And as I've said, the trend is that this is changing, that the way damages are being awarded is becoming more generous, but that is mostly anecdotal. And another thing which is important here is that compared to other countries, there is not so much weight given to an infringer's bad faith behavior, so somebody infringing knowing that they're infringing. Instead, what tends to be accounted for is the impact of the infringement on a company. And I think that my colleague Amy here will give you a better understanding of this in her discussion of Chinese trademark law. Okay, next, litigation. This is fun, actually. There is no discovery within Chinese IP as it stands. What does this mean? This means that if you want to collect evidence about infringement, you're going to need to do it yourself. And it's fun. Here at Kangxin, we actually have our very own investigative team who go out and undercover into factories and to trade fairs to find infringing goods, so things which are infringing patents or things which are bearing the logos of our clients. And then we will also conduct purchases, do purchase notarizations, and then be able to do an analysis about this to bring as evidence to court. So this is quite special to the Chinese system. It's quite an interesting part of our jobs here. Okay, copyright. So copyright in, I think, almost all jurisdictions, or every jurisdiction, it exists the moment that you have created and fixed that that thing in a specific media, okay? So the moment that you create it, it exists. Copyright naturally exists. However, in China, generally speaking, we recommend registration. And why is that? Because it acts as prima facie evidence, okay? It proves that you have some level of right of ownership. And when you go to Taobao, when you go to Alibaba, if you see somebody who is selling your goods or is selling something with your trademark on, or is infringing your patent right, copyright. When you're talking about copyright, if you have this copyright certificate, you can just use this to apply to Taobao and to Alibaba, and that will be enough to get them to take it down. Something that I'd like to get all of you to do, if you have time at the moment, is to go online, and on Taobao it's very interesting, although that I think a lot of it's in Chinese. You can actually search by picture. So if you have a good and you want to know, is my product being infringed, you can just put a picture of your product up, upload it, and see what results come back, to have an understanding about whether your products are being infringed. And on Alibaba, of course, they have an international site, and you can check on that as well. Okay, finally, customs. The customs system here is interesting in that it doesn't just inspect imports, okay? It also inspects exports. So that means that it makes a lot of sense to register with customs. You have to register, okay? And when you do that, the customs, they will, like the regional customs, they will ask you to give them a whitelist. So if you have a distributor, or if you have if you have a company that you're working with, if you have an OEM, then they will be allowed on your whitelist, and their imports and their exports will be allowed through. Apart from this, something which isn't necessarily, or it isn't specific to IP here, but is quite characteristic of the Chinese system, is very much the move towards mediation. Okay, so mediation is strongly encouraged, negotiation is strongly encouraged within the Chinese legal system. And good faith negotiation. This can have an impact on the case, on any further action that you bring. So that's something really to consider if you do want to bring litigation against, if you do want to bring an action against a suspected infringer. That is all from me for now. And I'm just about to hand over to my wonderful colleague, Amy Guo, who is going to talk to you a bit further about trademark law. Thank you for listening.
Thank you, Neil. Now let's move on more
Amy. Let me introduce Amy just briefly. Amy is a trademark attorney specializing in trademark infringement, copyright infringement, and unfair competition disputes. So Amy has gathered years of experience in handling trademark oppositions, trademark nullifications, and administrative litigation, legal counseling, IP custom protection, and advising domestic and foreign companies on legal issues in China. So Amy, over to you.
Hello, everyone. My name is Amy Guo. I'm a trademark attorney based in Beijing. Today, I'd like to make a very brief introduction of Chinese trademark law for you. I will introduce the main organizations involved in Chinese trademark law, the basic principles, and how to calculate infringement compensations in China. Okay, let's start. Next slide. The main official organizations to handle trademark applications, oppositions, and non-use cancellations are the China Trademark Office. And for trademark nullifications, reviewing rejection decisions, the Trademark Review and Adjudication Board. If you are unsatisfied with the decision made by the Trademark Office, you have the right to file a review application before the Trademark Review and Adjudication Board. And if you are still unsatisfied with the TRAB's decision, an administrative lawsuit can be started in the court. Let's move on to the next slide. Currently, there are two main principles regarding how to determine trademark rights. They are use in commerce and first registration. Use in commerce means the party who used the trademark first owns the trademark right. And first registration means the party who applied for the trademark first owns the trademark right. Next slide. In China, we use first registration as a basic principle. So it's vital to file a trademark application as early as possible. Otherwise, it might be escorted on by others. There are a lot of bad faith trademark applications made in China, and it can take a lot of effort to deal with them. Next slide. After obtaining the trademark right, if you find someone is conducting infringing activities, you can sue the infringers and request for compensation. The compensation can be calculated through the following ways. The infringer's profits obtained through the infringing activities, and the right owner's losses caused by the infringing activities. Finally is the reasonable phase of rights protection can also be requested for. If you can provide enough evidence to prove the infringers are conducting infringing activities with very obvious bad faith, the compensation could be treble damages. And if the infringer's profit and the right owner's losses and other above-mentioned factors are very difficult to prove, the judge may grant a statutory compensation against the infringer. The highest statutory in China is 3 million yuan. For this kind of evidence, you can provide some trademark license agreements as evidence to prove the value of your trademark. And the court will refer to the license fee when determining the compensation. Okay, let's move on to the next slide. Next, I will introduce the trademark administrative procedure. Let's take a look at this chart. This timeline starts from the application date of a trademark. The first period is examination. After receiving the applicant's trademark application, China Trademark Office will conduct an examination to determine whether it should be approved for registration. The examination includes whether the mark has distinctiveness, whether it contains factors that cannot be registered, such as place names or products' generic names, and whether the mark is the same as or similar to other prior registered trademarks, etc. The examination shall be conducted within 9 months of the application date. If the mark applied for complies with Chinese trademark law, the Trademark Office will publish a preliminary examination announcement within 9 months. If the applied mark violates the regulations, the Trademark Office will issue a rejection decision to the applicant. In the case that the applicant does not agree with the rejection decision, they can file a rejection review application before the TRAB. Next slide. The second period is publication. The publication lasts for 3 months. During this period, any person may file an opposition on the basis of absolute grounds. Any prior rights owner or interested party may file to oppose a trademark application that has been published on the basis of relative grounds. Next. Absolute grounds are defined in Article 10 to 12 of the Chinese trademark law, and they can be summarized as these 4 parts. The first one is same as or similar to the name of an administrative area. For example, CHINAR, China, cannot be registered as a trademark because it contains the country name CHINA, China. and only is a character R. So this cannot be registered because it will be deemed as a similar mark to China's country name. The second one is same as or similar to the official signs or hallmarks. For example, CCC is the acronym of China Compulsory Certification. So any marks same or similar to CCC cannot be registered. And the third one is the registration was obtained by deceptive means. For example, a mark contains beef cannot be registered on fish food. Because the customers may misunderstand that the products with this mark contains beef, but actually it did not. It is fish food. So the last one is lack of distinctiveness. This is very easy to understand. I believe every trademark applicant wants their mark look very special and easy to understand. For example, a very simple line or a very simple circle. Of course, it cannot be registered as a trademark. So let's move on to next slide. This is relative grounds. Relative grounds can be summarized as these four parts. The first one is the mark constitutes same or similar marks with others prior marks on similar goods. The second one is the mark constitutes same or similar marks with registered well-known marks on different goods. For these two relative grounds, I can give an example using crayfish. If crayfish is a normal registered trademark in Class 30, food products, and we found another trademark, Crayfish Plus, it's very similar to crayfish, right? And this Crayfish Plus applied on similar goods. It is also applied on food products. We can file a trademark opposition against this Crayfish Plus because they are, and the success rate of this opposition can be very high. However, if this Crayfish Plus were applied on different goods, and the success rate of this normal trademark opposition will be very slim. But if crayfish can be recognized as a well-known trademark in China, the success rate of this opposition will be much higher. The third one is a trademark contains a geographical indication, but the designated goods are not from the region indicated therein. For example, Woodbridge is a town name in England, right? And if a mark applied contains Woodbridge, but the designated goods of this mark are not from Woodbridge, it can be opposed, and the success rate is also very high. The last one is the mark infringes other entities' other prior rights, including but not limited to copyrights, trade name rights, and design patent rights, etc. For example, if you find a trademark contains a graphic element which you own copyright against it, you can file a trademark opposition against this mark using your copyright as a prior right against this graphic element, and the success rate will also be very high. Let's move on to next slide. If the trademark is opposed successfully, the trademark applicant shall have the right to file an opposition review before the TRAB. And where no opposition is filed after 3 months, the application shall be approved for registration, and a certificate of registration shall be issued to the trademark applicant. So let's look at the third period. The trademark is validly registered. A trademark registration shall remain valid for a period of 10 years from the date of approval for registration. Where a trademark registrant intends to continue using the registered trademark, the registrant shall go through renewal procedures within 12 months prior to the expiry date. If the renewal deadline is missed, there is a grace period of 6 months. Each renewal of registration shall be valid for 10 years. During the validity period, the following actions may be taken against the registered mark. The first is nullification. A registered trademark shall be declared invalid by the Trademark Office on the basis of absolute grounds, or its registration is obtained by deceptive or other improper means. At the same time, other entities or individuals may file nullifications against the registered trademark before the TRAB on the basis of relative grounds within 5 years from the date of registration. If the disputed mark was obtained through bad faith, the owner of well-known trademark shall not be bound by this 5-year limitation. Finally, it is the non-use cancellation. Where a registered trademark has not been in use for 3 consecutive years without justification, any entity or individual may file a non-use cancellation before the Trademark Office. So that is the whole procedure. And if you have any questions, you can join us in the Q&A session. Thanks for listening.
So now I can just spend a very quick couple minutes to tell you a little bit about Crayfish. Thank you both to Nell and Amy while you're getting your question ready. So Crayfish helps in a multiple ways if you're looking for help in doing business in China. And just actually on the point of trademark, Crayfish is our trademark. We registered in the UK under various categories, but our company name is actually called crayfish.io, which is also the domain of our online platform, the first marketplace in the world that is dedicated to providing Chinese business expertise online. It is a self-service platform which businesses and service providers can transact online. But for those complicated projects, or if more than one service is needed, we do offer tailored project management to help handle and deliver the service required. So the service areas covers all aspects of doing business in China, from strategy to IP protection to HR and sourcing. Specifically on trademarking service, we do help working with Kangxin, with Nell and the team. We help manage the whole process of trademark registration, including transcreating, which means not just translation your English name, but make sure they fit nicely in the Chinese culture, that they're ready to register, and even including redesign your brand logo, etc. So if you have those requirements, do speak to us afterwards. So now we would like to take some questions. Right, so we do have a question now. So it's from Damien. What counts as non-use of a trademark? Does one have to advertise, or is selling product to China, a Chinese company, sufficient?
Sorry, can you repeat the question again?
Sure. What counts as non-use of a trademark? Does one have to advertise, or is selling product to Chinese companies sufficient?
Non-use cancellation is if you applied for a trademark but you do not use it after registration, and any other party can file a non-use cancellation, and it must be registered for 3 years. The non-use cancellation has a time requirement of 3 years, and these 3 years can be during the registration date from in the registration period. And any party can file this non-use cancellation.
Okay, next question, please.
This question is, should I register a trademark in color or black and white in China?
Oh, that's a good question.
Yeah. Normally speaking, companies are preferred to register black and white trademarks because it has a wider protection scope, yeah. And if you only register a color trademark, the protection scope can be very limited.
From what I understand also, if you register in black and white, it can be more difficult to get it registered than if you are registering in color. So sometimes where there are similar trademarks, it might be easier to get your trademark registered in color, but it would also, of course, narrow your scope.
Yeah.
Okay.
Okay, next question.
We have another question. It's not very clear, but it says, if our company register our company name, what about our products category names? Should they be registered the same time?
Oh, that's a good question.
Yeah, I think it's better to register as a trademark too.
Yeah, I mean, I think in a lot of cases, there are a lot of bad faith trademark applications. So after you've had your trademark registered in China, if you haven't registered the brand names of your products, then there may be bad faith infringers looking at your products to see what they can register, so that you then have to negotiate with them. And that's where it really becomes an issue, because it's very expensive and very time consuming.
Yeah, actually, most company has a misunderstanding that only the company name can be registered as a trademark. But in our legal practice, many the product's name registered as a trademark is also very important.
Okay.
Great.
Sorry.
I was just saying that's a really great question.
Okay. Another one. Are there standard costs behind simple trademark applications?
Standard costs, as in official fees?
Yeah. I think
Yes.
the question would say, are there standard costs? So the question is yes, right? Okay.
Yes. And if you'd like for us to register a trademark for you, you can get in contact with Crayfish and we'll give you a quote.
Thank you. Now, next question. How long do patent applications take and how much does it cost?
Oh gosh, that's a very good question. So how long is a piece of string? They're pretty, they take a long time. It's a number of years. And we're actually going to have a more in-depth discussion of patent law, I think on March the 5th, which will cover more topics to do with that. But they are expensive, more expensive, and much more time consuming than trademarks. And the reason is actually because patents are stronger Generally speaking, with any form of IP, the more difficult it is to get a right, the stronger that right is. Okay, next question.
Yes. How important it is to have a Chinese name of the trademark?
Oh, it's vital. It's really vital. Gosh, if you don't get your Chinese name registered, the reason why it's really important is because if you don't register your Chinese name, oftentimes your English name will then be transliterated by the Chinese market, and that can sometimes be something really unflattering. So it's really best to get that name created, get something which has a good meaning in Chinese, so that the characters like they're auspicious and they really make the consumers want to come to you, as opposed to letting the Chinese market just give you whatever name it wants, because they will.
I will give an example to that now. Actually, one of our clients have a company selling education solutions, and one of its products is called Footprint. And footprints, the most obvious translation for that in Chinese is 足迹. It exactly means footprints. However, that is already taken in China when the clients wanted to register with your team. Now check that. And so the client said, okay, I'm not going to bother to have another Chinese name if it's not exactly what we want. But then the Chinese partners started using it as 足迹. So we have to go back to the client to say, you've got to register, because otherwise you got to come up with another name. Otherwise, all the teachers will be calling that name, and then you will not be able to correct that later. So you naturally will adopt a nickname. So now then we talk to the company, and they are now happy with 图记, which is similarly what means that, but at least it's protected. And right at the beginning, the market start using that. The next question is, to prevent infringement, is it advisable to file Chinese design registration in addition to Chinese patent utility models? So I repeat, to prevent infringement, is it advisable to file Chinese design registration in addition to Chinese patent utility models?
Well, that will really depend on what exactly it is that you want to register, the good that you want to register. As I said before, we're going to have a really in-depth look into patent law on the 5th, and I'll be here with Yuan Li, who spent 8 years working in SIPO and is really hot on this stuff. So please come back for the 5th, and you can ask us anything you want to then.
Okay, great. So that's the end of the question session and end of our webinar. Thank you very much, Neil and Amy, again for your great insight, sharing, and knowledge. And thanks to everyone who's listening from everywhere. We will be follow up with the email to send to people and with the links on the presentations. Thank you, and see you on the 5th of March on the next session. And we do also have other webinars which are not on IP. If you have a look on our events page, you will find there's some cultural and business and marketing webinars as well. Thank you and goodbye.